Hello and welcome, ladies and gentlemen, to another episode of The Agenda. Today, we will be focusing once again on key issues pertaining to law and economics. Our focus today would be on development and the role that the law plays in it. For this session, we have with us a person who needs no introduction to those who are law students or enrolled at the bar. But for those who are not, we will be presenting an introduction to Dr. Lalit Bhasin. Welcome, sir. Very warm welcome to you. Dr. Lalit Bhasin has been at the bar for the last 58 years. He is currently the president of the Bar Association of India, president of the Society of Indian Law Firms, president of the Indian Law Foundation, chairperson at the Chartered Institute of Arbitrators, and former chairperson at the Bar Council of Delhi, and a former chairperson at the Film Certification Appellate Tribunal. He is also trustee at the Observer Research Foundation. A very warm welcome to you, sir.
Thank you.
So our focus today is going to be on law and development. Now, this is an area which the Indian Youth Economic Association has been focusing on for the last 8 years in terms of its research. And we believe that both the economy and the law must not be read or studied in a vacuum. Both must be read in accordance with the other. And the old adage goes, as we say from time and again, that the law follows the merchant. So, Dr. Bhasin, my first question to you for today's podcast is this. Has the law been able to catch up with the economy, with the progress in development, and even with the incoming new, recently developing technologies that bring us that development? Has the law been able to catch up or get up to pace with that?
See, very relevant question, but the answer is a bit complicated. That law is a man-made thing, you see. Either the parliament makes the law or the judges make the law, or there are conventions and all that which have the force of law. Therefore, law keeping pace with development, it all depends upon those who are in charge of, who run the affairs of the country, who are governing the country. So if there is a mismatch, it is attributable to the same people who are responsible for the development of the country. And if the laws are lagging behind, then eventually it is their responsibility. It is the executive's responsibility to ensure that laws are made to keep pace with the development. Well, in India, I feel that we have, in some cases, kept pace with development. In some cases, we have gone overboard, the sense of over-regulation. I personally feel that we have too many laws and many regulators which are not required and which are not actually good for development as a mission you see which the government should be doing. Therefore, I would say yes, law has been able to keep pace with development, but if at all there is a failure, that failure is attributable to those who are responsible for development, not for those people you see who are administering justice and administering law. So that would be my brief answer to you.
Okay. So the focus point on this, or if at all we look at responsibility, lies more with the executive and perhaps the legislature as opposed to the judiciary when it comes to the law keeping pace with development. I think that that's a very relevant point. And if we see some of the recent developments in commercial laws, whether arbitration or for that matter the insolvency code, we've seen these trends where we've seen the parliament sort of going back every 6 months and amending the same code over and over again because the judge has given a particular interpretation, and then we sort of start the entire process from ground zero. I think that's absolutely important. That
The important omission in the approach is that we give too much of importance to law, but we do not give importance to justice. Actually, law is a part of justice. Our constitution, in the very preamble, recognizes the important role of justice. It says that we will ensure that justice, social, economic, and political, is made available to the citizens of this country. So emphasis is on justice, and it is connected with the economic, development. In the field of economics also, there should be justice, as in the field of political activities, as also in the field of social network that we have. Therefore, justice has to be considered as something which, of course, law forms a part of it, but justice is like a divine concept, whereas law is something which is man-made. It has to be subservient to justice. Therefore, if our parliamentarians, legislators, they recognize the role of justice, and our government, which is responsible for development, if they keep in mind this preamble of our constitution, that justice has to be ensured, economic justice, there would be no mismatch. I think you can move forward because that is the mandate which we have given to ourselves, we the people of India. But justice has to be seen, and as Aristotle Aristotle said, you see, um, many centuries ago, that at his best, man is noblest of all animals. Separated from justice, he is the worst. So this applies, you see, to our administrators, this applies to our legislators, those who are responsible, this applies to our judges, those who are responsible for the administration of justice in this country. And that is where you see the difference in approach comes in when you put too much of emphasis on law. Law is nothing but a man-made thing, you see, that you have to follow.
yes, I think that's absolutely relevant, and that gets me to the point that the preamble and the Constitution recognizes justice in terms of not just social or political, but economic as well. And while there is ample discourse on the question of economic equality, and that being a possible goal and objective of the state and policy, very often what is forgotten, especially in the context of India, is the objective or the ultimate goal of economic liberty as well, right? And I want to get to the point where you're saying, I think that's absolutely relevant, that India is certainly an over legislated country, right? We didn't repeal many laws coming in from the British era. Sure, some of them have continued to be useful, but at the same time, when we talk about regulation of business, we see that there is overregulation. There are outdated laws. There are excessive laws which give too many powers to the bureaucratic machinery and takes away the power not just from the businessman but even from the individual. Right? We're talking about here not necessarily a large corporation but sort of small proprietors running their businesses as well. And the law, in some sense, forces them to stay small because growing up in size would mean that they would have to comply more. Sometimes we see there are hundreds of permits that a small restaurant owner has to take before he starts his business. So that part is something that's, do you think that's sort of keeping India behind and sort of not letting us unleash the full potential of what is termed as the India growth story, so to say? Do you think that that aspect of over-regulation is something that is keeping Indian businesses behind?
Yeah, it's absolutely correct. You see that there are so many impediments uh, in carrying out our business activities. And as you rightly said, even for setting up of a restaurant or a hotel, you need more about nearly 150 permissions and sanctions and all that. And all that talk about one window clearance, that is only a lip service. It in reality, you see, you continue to apply, and sometimes no reply, no reply. No reply. That is what happens. And if and when you get it, you see that is quite delayed. Even in the matter of renewals of the licenses, because these are mainly yearly licenses which are given, you see, to the business owners. You apply in time, but you will never get, you see, the approval or the renewal in time. Therefore, technically, you may be in breach of law because you may be carrying on your business without a proper and valid license. It is therefore not only that we have too many laws, we have overlapping laws, we have outdated laws, we have very ill drafted laws, which which is good for lawyers. Lawyers get more work, you see, because if there is confusion in the drafting and all that, but not good for the country, not good for the economic development of the country. And then what happens is that it is not just the law itself, it is the subordinate legislation, you see, the regulations and the rules, you see, which come in, which create more and more problems besides implementation of the law itself. Too many laws, and then what is a very significant impediment is frequent change, you see, in the policies and policies relating to economic activities and running of the business. For instance, you will have a FDI policy which will undergo change next year. Then again, year after that, again they will that will undergo change. Same position with regard to our taxation structure. It keeps on changing. Therefore, an investor, and particularly the foreign investor who wants to make an investment in India, he's not sure as to whether he'll get any return on his investment. If at all he'll get, what will be the quantum of that, because they go by projections. The investors, they go by projections for the next 5 years. This is my investment, this is the return I will get on my investment. But those policies, you see, they keep on changing. Therefore there has to be like a amalgamation of policy and practice. As I said, it's very well known in Manu Smriti. You see, it is said that one is niti, other is nyaya. Niti means the policy. It has to be a policy, means a very good policy. And nyaya means, you see, justice and law and all that. So there has to be an amalgam of niti and nyaya. Otherwise, this will lead to this very serious but very interesting thing, what is called Matsya Nyaya. Matsya Nyaya. Matsya means, you see, fish. Nyaya, fish. That is the fish. What the bigger fish, they swallow, you see, the smaller fish. This is what happens if there is no merger or understanding, you see, of policy. The merger of Nyaya, Niti and Nyaya, they have to go together. But in India, our nitis keep on changing every time, and law remains stagnant, or they bring more laws, and laws bring more regulators. Of course, you are giving employment to either retired judges or the retired, you see, bureaucrats or other people to whom you want to give some favors. But we have too many of these, and I think that is a big impediment. And just add to that the notorious laws delays. Notorious laws delays. Now, how would an investor feel that why should he come to India, supposing there is a dispute with the local joint venture partner here? How long will it take? How expensive it will be? I think I don't have to tell most of the viewers, and you also, and the law students, that they are aware of this, that there are more than 3 crore cases which are pending in India. Therefore, litigation has virtually broken down. The system of administration of justice is broken down because the citizens of this country are not getting justice at all. These days, particularly during COVID, and now they call post-COVID, but I think it is still the COVID period. Post has yet to come, and I think it may last, I don't know what, 6 months, 1 year more. But during this period, what we have seen is the emergence of what they call the virtual courts. Now, these virtual courts, what are you see they achieving? Yes, they hear some matters which are the registry says are very important matters. Okay, urgent matters. The registry decides what is the urgency, why these should be taken up. So only those matters are taken up. These are fresh matters. What happens to those matters which are pending since 1970s, 80s, and 90s? No one is bothered about that. So again, let us stop all this lip service which we are doing. It's a big impediment. Therefore, is arbitration the answer? Again, the answer is no. Arbitration is not the answer. For the very simple reason that it is virtually cartelized, you see, uh, by the retired judges of the Supreme Court and High Court, and it takes now almost the same time as litigation, and it is more expensive than litigation because there are three retired judges forming the tribunal. They hear the matter. You have to pay for that. Therefore, arbitration, despite several amendments being made in a new act which came in 1996, itself has failed to be the alternative to, litigation. So, what is the answer? The answer is that even our investors would feel that they are comfortable mediation. Mediation would be the answer, but we need trained mediators who in whom the parties can repose confidence. These are, you see, the various impediments which any investor face and which hamper economic development, because economic development depends upon investments and fair dealing. That is where we are lacking, you see.
Some very pertinent points here, Dr. Bhasin, and I'm in absolute agreement here that at times when we talk about alternative dispute resolution, that doesn't necessarily speed up the process. And what would you think about? And I would like to know your views about this now that we are on this question. Very often, I've discussed this with a lot of advocates that there is a need perhaps to have arbitrators who aren't necessarily lawyers or judges. Right? We see that there's a legalization. I mean, it's not that it's criminal, but there is the role of non-lawyers in the arbitration process is something that we don't see as we would have wanted it to. Right? For example, having sort of engineering people coming in from an engineering background, because we see that most of the NHAI arbitration matters, or for that matter, anything that's got to do with sort of construction contracts and the like, right? Domestic or international, or that involving the government. On some level, don't you think that on a panel of arbitrators, and even for that matter, those who are pitching, right, those who are arguing for a party, on some level, because we're looking at the contract, where an interpretation of law will play an important role, but at the same time, when we're looking at tangible facts, right, some of the questions that arise most of the times in arbitration matters include who's responsible for the delay. Right? Or almost every big arbitration matter will have this question pop up at least once. And on some level, people who've had a life and career in the law might be able to understand the law completely well, but there is a technicality attached to the science behind it. And perhaps an engineer would be better able to understand that problem. So, what do you think about perhaps having, let's say, engineers, or when we're looking at sort of sporting arbitration? So, there are some sporting personalities there as well, right? Coaches and the like, international sporting arbitration, etc. But what do you feel about getting these experts on board as arbitrators? Do you think it's a good idea? I'm sure it's
See,
done in small
you,
pockets.
yeah, you have actually hit the nail on the head. And as legally we say, we are both ad idem on this. I have been a champion, you see, I have been pioneering this thing that arbitration should not be monopolized by judges and lawyers. There are people who are experts in respective fields. Because what is arbitration? Arbitration is deciding the disputes. Now, disputes, when they arise out of the facts. One party denying, you see, the rights of the other party, and eventually it all comes down to money matters and some construction contracts, building completed on time, not completed, what are the deficiencies. Similarly, in intellectual property rights, you see, all these are all essentially questions of facts where some expertise, outside expertise, is required. Expertise, as you rightly said, you see, of the engineers, of the architects, you see, of company secretaries, of chartered accountants, of even some retired bureaucrats, you see, who may have experience, wide and varied experience in different aspects. So, but that can only happen if you have institutionalized arbitration. In India, that is what we are lacking, and that is why we are lagging behind in field of arbitration, because we do not have institutes like the LCIA or the ICC or the SIAC of Singapore. Even Malaysia is, you see, moving forward. Dubai has got an excellent institute, you see, of arbitration, and in India, we don't have. Some steps are being taken. We have in Bombay the Mumbai International Arbitration Center doing a very good job. But we need many more institutions. And that is where possibly even the chambers of commerce have to come forward and create these institutions and have a cross section of people, experts, as panelists, you see, who can be selected to be the arbitrators, along with, say, some retired judge of the High Court, some lawyer, because some legal issues would always be there. But it should be more broad based. So you have to involve. I think I'm glad you asked this question, because I have been this thing has been agitating me also, and I've been advocating for this enlargement, you see, of the area of arbitration. But
Absolutely.
we, we do need trained arbitrators. Therefore, what we are trying to do in the Chartered Institute of Arbitrators is not just train, you see, the judges and lawyers. Well, judges and all, they feel that they don't need any training. They know everything about law, they know everything about arbitration. But other people, like architects and engineers, you see, and other people, they need also to be trained properly so that they can understand the fine nuances, you see, of arbitration, not just the law, but also the technical aspects.
Absolutely. I think one can hope, and the great work that the Institute is doing as well, and other arbitration centers, that we see a more broad based panel where we get experts coming in from different fields. A question on that end that has always sort of perturbed me in that sense is the example of the Competition Commission. That on some level, we don't see either lawyers, judges, or sort of trained microeconomists sitting on the Competition Commission. Right? We see most often retired bureaucrats. Sure, they might have an economic policy background in some cases, but when it's coming to the question of law and economics, you'd rather have, let's say, a microeconomist or someone from a legal background sort of being on that panel on the commission, because very often we see in the European Union, like even the advocates have along with them someone who's a PhD in microeconomics who looks at the pricing models and the like. So here's hoping that the law sort of or the field of arbitration sort of expands and gets others from other neighboring fields and makes it a more interdisciplinary approach. On that note, Dr. Bhasin, I want to get to my next question, and after that we will open us also maybe questions from the audience. We do believe that we have some comments coming in from the audience. So just a message for the audience here on either of the platforms. Please feel free to pitch in your questions. We'll take them up after this question. So, Dr. Bhasin, we talked about how the law has been an impediment, right? How at times we see overregulation, and because of that, development is not able to sort of sort of happen, or at least the laws have not been able to keep pace with it at most times. But what about the law serving as a means to support the development? Is that possible, right? Where it becomes an enabling factor, where the law becomes a carrot rather than a stick. Sure, we see that the law is supposed to punish, and coming from the whole Austinian school, okay, the law is not meant to reward. But is there a possibility, if not through court, certainly, as you pointed out at the beginning, the responsibility is with the lawmakers and those who are responsible for the development, like on some level, the executive as well. You've talked about FDI policy, you've talked about how laws are sort of outdated. In that sense, how can the law be an enabling factor to push forward and sort of spur the economy? Is that a possibility? And what, if at all, how can the smaller businesses also gain from such a setup?
Yeah, I think very relevant, and uh, I have seen in some very recent times the government taking some good initiatives in the matter of rationalizing the laws. Because what you asked is how law can be a vehicle for economic development. And that can happen only if you have proper laws in place, not too many laws. Therefore, the government has initiated, uh, even Dr. Vivek Debroy had said, you see, there are about 1,000 so many laws. We need to reduce them to about 200 laws, and that will serve. Therefore, rationalization process has been set in motion by the government. And second move by the government is also to now make it really happen. Ease of doing business. Ease of doing business also includes making it easy for the businessmen to do business without fear of breach of law. That is important. Therefore, the recently the DPIIT, which looks after about 11 laws, it has decided to initiate steps to decriminalize some, what are till today, what are the offenses under various laws, you see. Okay, impose some fine on them, but decriminalize so that people who may be accused of, say, non-filing of returns or non-filing reports in time, whether under the Companies Act, you see, or even these 138 cases and all that should be decriminalized, and effective steps are being taken. But one important major reform is in the field of the labor area, the labor reforms, where the government is now proposing to bring in three new codes. which We have about 54 laws covering, you see, the labor legislation, but now they are proposing to bring three codes. One is the code on industrial relations, which will make it easy for for the employers to hire employees, and also under certain circumstances to dispense with their services, but giving them proper protection of some sort of compensation to be paid to them. So that what the Americans call hire and fire policy, it is not hire and fire, but it is freedom to hire and freedom, you see, to ask the employee to leave on certain reasonable terms. So that is the labor under the industrial relation. Second reform is the code on social security, which is very important. You see that every employee, whether he is a temporary employee or even a contractual employee, they must get the benefits of these labor reforms. And the third one is code on occupational safety, health, and working conditions. Again, very important, both in the establishments as well as in the factories, and particularly for the our lady workers and employees, you see, who are handicapped. So some steps are being taken, and that is a welcome step. But what needs to be done is also a message for our judiciary, that even judiciary should be consistent with its judgments. We see very often that one judgment of the Supreme Court has come today, then there will be a larger bench set up to see to reconsider that judgment. Then what is the law? People don't know what is the law. You see, whether it is that three judges bench or the five judges bench, constitutional law, again subject to review, and so. there has to be a consistency, because particularly by the Supreme Court, because Supreme Court, you see under Article 142, whatever it says is the law of the land, applies everywhere.
Absolutely.
Therefore, consistency in judgment also will bring in consistency in law, in understanding and interpreting the law.
Absolutely, absolutely. I think that's a very valid point there. Like the prime example of a Bangalore water supply, the definition of industry, um, one sized bench, it sort of keeps on going to a larger sized bench. So on that end, we had a similar case of the Jindal stainless steel on the question of sort of taxation, compensatory taxation. So yeah, it took years to sort of get to the point that we eventually got to with Jindal. So on that, that's a very relevant point. That and on some level, we've discussed this in some of our older podcasts as well. That this is a great time because very often we see in these sort of larger bench matters, these 9, 11 judge matters, we see that the rest of the court comes to a standstill, and we see a lot of
Absolutely.
lawyers coming in only for one matter. If this can be done during these COVID virtual hearing times, which is, I think, probably the best way to deal with these matters, because one, the court is anyway at a standstill, and two, this whole business of sort of 50, 60 lawyers moving in for one matter is something that can be dealt very well, especially in these virtual hearing times. This is my opinion that maybe the larger bench matters, all of them. This reference that just came in yesterday to an 11 judge, the Maratha
Yeah.
reservation matter. I think it's a good time maybe that the Supreme Court can have all the longest, the largest matters sort of listed before
Yeah.
it. Before I get to the questions, Dr. Bhasin, just a last point. You did mention the point about ease of doing business. Most certainly, India has been climbing into the ranks. But is there possibly a fear in you that this is probably only because of uh, perhaps gaming the numbers, as in gaming the system, ticking the boxes, rather than actual tangible change happening for ease of business? Is there a possibility that we're just sort of fitting in the algorithm and say, okay, fine, these many days in the Commercial Codes Act, now we're done, we've moved up one rank? So, do you think that this is leading to tangible change, or it's only on paper?
No, it is. I don't think, you see, one can look at it in a superficial manner. The process of liberalization started in early 1990s, and that is a step in the right direction. And there has been no turning back on that. Each successive government, whether Congress or BJP or by whatever name called, they have been taking steps to strengthen the economy of the country by taking some positive steps. Now, ease of doing business in a country like India, where there was Inspector Raj, you see, it is not easy, but steps are being taken to facilitate the Indian businessmen, the foreign investors, to set up their industries in India, to set up joint ventures. That is a meaningful exercise. But as I said earlier, there are impediments there. So basically, these impediments have to be removed. Then you will have a full flow, you see, of investment in India, resulting in total development. And soon, I think, as predicted in 2025, we will be really, and not superficially, among the top five economic powers in the world if these impediments are removed. It is subject to this qualification. But steps are being taken, and I'm hopeful that proper results will be achieved.
Certainly, but we can be hopeful about that. That's the least, at least in our end. Dr. Bhasin, we'll take a question from the audience. This is a question that is from Bajaj Indian Homestay. Right? So it says, is there a possibility where a parliament can pass a law to reduce existing 50 or so licenses to just a handful with an agreement covering remaining requirements that entrepreneurs can sign? I think once again, this is going back to the point that
Yeah.
we discussed earlier about sort of simplification of the law, of codification that is not many legislations but a few, and especially in the context, I take it this is from the hospitality industry.
Yeah,
So, some perhaps on the question of sort of codification, simpler codification, and if specific points can be made towards the hospitality industry in this regard. Sure,
yeah.
possibility constitutionally there is, right? The parliament can do so. But perhaps even the role, as you mentioned, of delegated legislation here maybe plays some part too.
No, it is not only that, because you see in our constitution there is a separation of what the center can do and what the states can do. You see, under our schedule 7, there is the union list, the state list, and there is a concurrent list. Now, certain subjects fall under the state list, and this hospitality thing, the tourism and travel and all, that is also covered under the states. Therefore, it is not just the parliament. I think the parliament and the state legislatures, they have to be in sync, you see, to take appropriate decisions and to reduce, you see, these system of licensing. And they should encourage and promote a one window clearance. It should not just remain on paper. Therefore, my answer is yes, there is a possibility, but you have to take on board the state legislatures also.
Absolutely. I think that's a very valid point here. That on some level there are aspects which are well within the state's ambit when it comes to the hospitality industry. But again, when we talk about something like international tourism, right, or tourism coming in from sort of other countries, and we see sort of how technically tourism is not the export of a good, but we could say that just like the export of a service, it is getting in foreign exchange. Perhaps that kind of a benefit is not something that has been provided to the tourism industry. And most certainly that there is that constitutional separation of the seventh schedule. But one point here comes to my mind, Dr. Vasin, and I would like your points on that before we sort of bring the session to a close. I'm reminded of on this question, reminded of the Federation of the Hotels and Restaurant Associations of India case pertaining to aspect theory of taxation, where the question of entertainment and luxury, which were in two different lists, were brought together on the hotels, and both were imposed. Right? The court said, okay, no, this we're to look at the aspect, and on some level, the hospitality industry was supposed to sort of pay or sort of face the burden of both the taxation there. So, on some level, do you think that the federal system can also be a burden on the businessman, or perhaps specifically this particular industry?
You see, this is a very famous case decided by one of the ablest judges of the Supreme Court, Chief Justice Venkat Chalaya at that time. The dispute was about the luxury tax, you see, and the state act, you see. Luxury tax was the central act, and there was another state act. So the hoteliers and the FHRAI, whom you named, it took up the issue, but the Supreme Court decided that these are two different enactments. One is under the center, other is the state. So both are competent to levy this. That is how this was decided. Therefore, I brought it out in answer to the earlier question that you have to take on board, you see, the states also. Therefore, center and states have to work together to reduce this uh, unholy burden, you see, on the particularly the tourism industry, the hospitality industry. And you are right that you are uh, by inviting foreign tourists to come here, that is in a way export of your tourism facilities, because they bring in the exchange, the foreign exchange, the foreign money, so they generate lot of business here. That is what even the export promotion councils are doing. I have been the founder chair of the Services Export Promotion Council, and there you see hospitality and healthcare. We try to promote the export of services. So we can't technically export, you see, tourists outside India, but idea is to invite people to make it proper and safe and secure for the foreign tourists to come and enjoy, you see, India as tourists.
Absolutely, absolutely. I think that's the That's the key takeaway from this, that on some level, state and center both have to sort of get on board. And on that note, Dr. Bhasin, before I bring this discussion to a close, just a small point for our viewers. Very recently, Dr. Bhasin has edited a compendium on the 70 years of the Indian Constitution, right? For those of you who can see, it's right here behind up my shoulder. And it's available on Amazon and all other platforms. And it has got articles and essays. I believe the first one is from Justice Sikri, and it has got
Yes.
articles from lawyers, advocates, members of parliament, and I think it focuses on very key constitutional issues. So those of you who are interested in constitutional law, and even those who are not, perhaps that's a great point to sort of start. So, Dr. Bhasin, many congratulations on the publication of this compendium, and thank you so much for joining us here at the IYEA
No,
for this podcast.
thank you, Ajay. It was a pleasure to be a part of this, and
Pleasure is all
wish you all
ours.
the best, and wish the
Thank,
viewers all the best. Thank you very much.
thank you so much, sir. Thank you so much. Thank you, everyone.